Do you have a will, and is it valid? That's a question you need to ask yourself. What makes a valid will? That's a question to ask a professional. Passing without having a valid will would just cause additional, unnecessary grief on the ones you leave behind. And it's no good cutting corners and copying your friend's will or completing an online will kit. When it turns out, if it's challenged and it's invalid, it was a waste of time and money and the whole reason why you had a will drawn up in the first place. Hi, my name is Rick Ward, and my mission at Your Journey Transitions is to provide you with all the information required to get the very best out of your retirement and to take the stress out of transitioning through the different stages of retirement. I will do this by informing you on who you should talk to, what sort of questions to ask, having the opportunity to visualize a meeting and to get your head around what type of questions to ask is going to make your meeting with your professional far more productive and efficient, saving you money in efficient time management. As with all my content, this is for educational purposes only and does not constitute any sort of legal advice. You need to get legal advice from your advisor in your locality. Stay tuned to the very end, where I'll provide you with some free resources to help you with your planning. Join me now as I have my basic will drawn up by my estate planning advisor, Catherine Lynch of Cariad Legal in Perth, Western Australia. Let's go meet Catherine.
Catherine Lynch. My business is Cariad Legal and I specialise purely in wills and estates. So that is everything from organising your estate planning, so your will, which of course is, as you're coming to understand, it's not just a one-page document saying I give this to this person. There's a lot more to it than that. Enduring powers of attorney and enduring powers of guardianship, and I'm mindful that I might be talking to people from outside of Western Australia.
Correct.
These documents, well, they may or may not even exist in other jurisdictions. Certainly, even within Australia, they're different in every state. The legislation behind them is different. So in Western Australia, we refer to power of attorney, power of guardianship, which are for when you're still alive and to give powers to other people to act on your behalf. Power of attorney is all of your financial matters. Power of guardianship is your health, lifestyle and medical decisions. And then I also do probate, letters of administration and assisting people generally when somebody has passed away.
Alright, we'll break some of those down later.
Yeah.
That was a big disclosure because this is probably going to be a worldwide sort of audience.
Yeah.
And so I find, even looking at it, the words for certain trusts and stuff they have that product, but it's under a different name. It's called something else.
Yeah.
So the main thing is everyone needs to get the professional advice in their neighbor, in their locality.
Definitely.
So,
definitely.
And even in Australia, that's the thing is people think that it's across, but WA is really quite different, isn't it, in laws around this?
Yeah. When it comes to wills, generally speaking, and I'm speaking very generally, and I suppose I have to have that disclosure that none of what I'm saying is legal advice,
That's right.
of course.
Of course, yeah.
But a will that I do here in Western Australia, it is going to be valid throughout Australia, and it's potentially going to be valid in other jurisdictions as well. But of course, you need to get.
So if I had my
advice.
will done with you and I moved to Sydney and I passed away over in Sydney,
Yeah.
there's still no problem. My will be
It can be used.
Okay.
That's correct. Now, if you, however, passed away but you had property in the US, then we'd be having a different conversation. Yeah.
Okay. And that's where I think mine should be pretty straightforward because I've had that, but I have. In other sides, my thing is really complex and unique because I do have companies and property in the U.S. and I have some here, and I have an ex-wife, but my kids are all grown, so I guess that makes it a bit simpler. And we've been divorced for a long time from their mother.
Yeah.
And I had my thinking, which a lot of people do think, if I put it in writing and I sign it, it's legal. So when the kids were little and we had the whole 2 wives and all this stuff happening, that just drew something up off of something I found on the internet and signed it. And I'm coming to know now that probably is worthless exercise altogether.
Yeah, and I do see that, as you can imagine. I see it a lot, and homemade wills, and invariably there's something not right with it. And sometimes we're talking about people with millions of dollars that have got a one-pager that there's just small things. They're simple when you know it, but if you don't know, I had a gentleman recently, he laminated his will. Just not something that you do.
Okay.
And it was actually witnessed correctly, but there was no way of telling who those witnesses were. They were signed, but there was no identification of those individuals. So how do you find them?
So I guess I'll find out how much details in an actual will, because I was thinking, sitting alongside that, one is I'm going to have a document that my wife's asked me for. She has no idea where our accounts are, who is to contact. And if I was to pass, yes, we have these, but what do I do with them?
Yeah.
And so I'm creating a document around that.
Well, as part of my service, when you do your will,
Yeah.
when I send you the draft,
Yeah.
I also send another document called a letter of last wishes and instructions to executor.
Okay.
So that is very useful. Some people don't even look at it because it's the will, of course, that's the legal document. This other document isn't legally binding, but the more you complete that, the more it's going to help your executor.
Yep. That's my thinking along the line is I want to get the legal stuff because I saw what happens when someone dies without a will in place and the dramas and stuff around that. So I want the legal stuff out of the way, but there's still some toing and froing, and I'm still trying to conquer what I want to do. So having these wishes, this is what I'd like to have happen.
Yes.
And I trust that my family will do that.
Yeah.
But legally, I want to make sure that it's as smooth as possible for them.
Do you want me to start by going through and taking your instructions?
Sure.
Yeah?
Yeah. Because
We'll do that.
Oh,
and
that was a point. Now, I'm still thinking through this whole process. I've been doing it. So to make changes to my will, I do my will now, and that's quite an easy thing. You make amendments to that will, or do I drop a whole other will when I?
Yeah, that's a really good question. So hopefully, doing your will with me, if I ask all of the right questions and I'm, thorough, your will shouldn't need to be amended or updated if things don't change. You'll hear some people say you need to update your will every 5 years. That's not true at all. And I've successfully had wills go through probate that are 30 years old. What you do need to be doing is reviewing your will regularly.
Right.
And my clients, of course, can call me, 12 months, 2 years, 5 years time and say, look, this has happened. Do I need to make any changes? To be honest, more often than not, no changes do need to be made. Of course, if something significant happens, such as somebody passes away, you fall out with an executor, a new child is born, significant life events, then you may well need to make changes. You may not. It depends, what was originally done in the will. But to answer your question, yes, it is relatively simple. If you brought to me a will that had been done by another lawyer, I would, of course, be able to amend that will. I'd be doing a whole new will.
Right.
But my own work, I can easily go in and amend.
Excellent. But most of our stuff's in joint names or something, so that's not really. What says here? Identify your assets. So what is?
Yeah. Well, let's go through that.
Yep.
All right. We'll start with the basics. So your full legal name?
Richard James Ward.
Richard James Ward. And what's your wife's name?
Karen.
And address? And your email? Phone number?
Mobile number or home number? Or?
Take both.
Okay.
Your date of birth? And your occupation. Okay, so you said you've got children from previous
I've got
relationships?
3 children from my first marriage.
Mm-hmm.
Do you want all the names?
Yes, please. Full legal name.
Yeah.
So, first question. Well, actually, first of all, what we might do is go through your estate before I ask you about executors and things. So, yeah, as I said, identifying your estate is important because your will only covers your personal assets.
That's something I didn't know before.
Yeah, that's a really key point.
Including life insurances and things like that. That's not
Excluding. Yeah.
See,
But you can incorporate them into your will, but we'll get to that.
Yep. Okay.
So your home, do you own that with your wife?
Oh, I do.
And
it's
do you,
a 50-50.
Is it 50-50 or is it joint? So that again is a key.
Oh yeah, it's joint.
Yeah. Okay.
It's joint,
So
it's a common joint,
yeah.
Yeah, we bought it together. And we also have a vacant block in Cully, WA, and and that we bought jointly.
Mm-hmm.
And then we have a house in Bustleton,
Mm-hmm.
and that Karen has 90%, I have 10.
So that one is tenants in
Yeah.
common. Okay.
Yeah. That's the only one we got in common.
So 90%.
Karen?
90. Why is it doing that? Sorry, just one moment. 10% brick. Okay, so they're the three properties.
Well, they're the three that are in our own names.
Right.
Everything else is in a trust or a company.
Okay, we'll come back to those.
Yeah.
So obviously you've got vehicles, personal possessions. That's assumed, in bank accounts.
Yeah, all the bank accounts are joint bank accounts.
Mm-hmm.
Yeah, all of our accounts across the track.
Okay, and then we come to your business interests. So you've got companies and trusts.
Yeah, we got a trust.
Mm-hmm.
I got a trust and a company here in Australia.
Are they all in WA?
Yeah.
Okay. And are you and your wife trustees?
We are.
Okay. All right. So you've got that trust that.
Both directors.
And are you both shareholders?
Yes. Equal shareholders.
Do you have life insurance in Australia?
We do. We both have it through our superannuation,
Okay.
which is HESTA,
Okay.
and I'm the beneficiary of hers, and she's a beneficiary of mine.
Yep. Okay. And then you have assets in the US.
In the US, yeah. We've got a limited liability company over there, and in that identity we have our house in America,
Mm-hmm.
and we have a stock portfolio managed by Rugi Wealth in Florida, which is inside the company,
Mm-hmm.
and we have a timeshare thing in Bonnet Creek.
Okay.
In Florida.
Lovely. Yeah. Okay, so let's talk through this.
Okay.
So you've got let's look at your Australian
Yep.
property first. So home as joint tenants, the two other properties as joint home as joint tenants, the block as joint tenants,
Yeah.
and then the house as tenants in common.
Right.
Okay, so the property in Bustleton, where you own a 10% share,
Right.
that is yours solely, and it comes under your personal estate and in your will. And of course, the other properties as well, if your wife was to predecease you, then of course they come under your personal estate. So even though people say, oh, everything's joint anyway, of course, when you both pass away, then you need.
Yeah, and
To have-
that's contingency. It's in the will as well, isn't it?
Yes,
Because I've got,
exactly.
this is the plan, basically everything going to her to start with. But if she goes at the same time,
Yes.
if she goes before me, then we'll get a new will. If at the same time, then
Yeah.
then it's divided between the kids type thing.
Yeah, yeah. So that's great. It's great that you're aware, because a lot of people aren't even aware, as we discussed, how the property is held. I'll talk about the life insurance and super, because that's what a lot of people in Australia at least have. Superannuation and life insurance, they're basically like trusts. So they're not yours. They're held for you for your benefit, but they're not yours. So your superannuation company, there is one exception, which is a government fund where you cannot nominate a beneficiary, but all of the other ones you can nominate, and you need to have a binding death benefit nomination.
Oh, that came up in your talk. I didn't know what that was. Explain
Yes.
that again.
So basically, it's you contact the company and they will send you out a form to complete, and you nominate who you want your super to go to.
No.
A death benefit nomination form, I guess the document is called.
Didn't we have that already when I put my nominee as being the wife? Why is it a?
Okay, so what you've got is lapsing and non-lapsing, generally speaking. So when you first set up the fund, you may well have put down made a nomination.
Right.
The difficulty often, and I'm talking very broadly because there's lots and lots of different funds that all have different policies, different ways of doing things, but generally speaking, these nominations are what we call lapsing. Every 3 years, you need to renew them if you want them to stay. Otherwise, they're just there as a record of what your wishes were 3 years ago or 10 years ago, whatever the case may be. So you need to make sure that it's up to date. And ideally, if you can make it non-lapsing, and different super companies may have different policies with regard to this, but if you can make it non-lapsing, so you don't have to make sure that you're updating it every 3 years.
I've never heard that before.
No, you wouldn't. People don't.
They don't
perhaps
contact
should be.
you and tell you that you need to change that.
No, they don't. They may send you out a form with a heap of other paperwork that you
And
don't
maybe
read.
mine is already non-lapsing, maybe if I
Possibly.
contact them. Okay.
Possibly.
And we both have the same super fund, so.
Okay. The other thing to be aware of, so there's lapsing versus non-lapsing, and then there's binding versus non-binding. So ideally what you want is a binding nomination. Now, if you don't have a binding nomination, then again, it's just basically an expression of your wishes. But the trustees of the superannuation company, they can overrule that. So if, for example, you had a girlfriend and you decided to make a nomination to your girlfriend of your superannuation, the superannuation company, probably quite rightly, would say, well, no, we're not making that payment. We're going to pay it to your dependent, who is your spouse. And they can override it. And so with a will, and of course, I've got to say, I'm talking about Australian law in general, but even with Australian law, the specifics are different in every state, and the case law is different in every state. But you've got the law that says, or sort of general idea of we can give whatever we want to whoever we want. We have a right to do that, freedom of testation. The law balances that out with our social moral obligation to our dependents. So yes, you can say, right, I'm not going to give anything to my wife, I'm going to give it all to my girlfriend. Your wife, as your spouse, as your dependent, can make an application to the court and say, I haven't been adequately provided for.
Cool.
So that's a whole other topic that
Yes.
won't delve into.
Well, we don't need to deal with that one, so to speak.
Yeah. So, right. So we've covered your super. Make sure you've got a preferably non-lapsing binding death benefit nomination. If you had life insurance, I'd be saying the same. You need a nomination. Make sure it's up to date.
Oh, but my superannuation and my life.
So it's
the same?
It's the same.
Okay.
Yeah.
So I only have to do the one, and it covers both because my life.
Well, just confirm with them.
Okay.
Yeah. Okay, so then we get to trusts and companies. Again, these are separate entities. They're not you, they're not yours, technically, and they don't die when you die. So, there's no point putting them in your will, because your will doesn't cover, your will is you, your company is a company. Of course, you can leave shares in a company, so if you own shares in a company, you can will those, because they are yours, you own them. The company itself, separate entity. So you need to make sure on top of your will that you have the company set up in such a way that if something happened to you or any of the directors, that there are mechanisms in place to replace that director, wind up the company, sell the assets, whatever the case may be. Yeah. And the same thing with a trust. So with a trust must eventually come to an end. But you are irrelevant to it, you as an individual. So there has to be trustees and there has to be beneficiaries with the trust. So again, if you're... Now, did you say that you and your wife are trustees?
You're right,
yes.
we are.
Yeah, okay. So again, the trust deed itself will set out. So it's like you've got, the will is for you, the company constitution or the company deed is for the company, trust deed is for the trust. Now there may be some overlap. Like I said, you may in your will give your shares in your company. You can do that through your will, and through your trust, for example, that might make reference to your legal personal representative. Legal personal representative is sort of a blanket term for the person who steps in as your personal representative. That with regards to a will is your executor. If there was no will, it's another term that's used, it's an administrator. Either way, they're both your legal personal representative. Okay?
Now, is that covered under another document? Through guardian or power of attorney or?
No, the executor is nominated in your will.
Okay.
That's the only place you can nominate your executor. Okay. Yeah. So if you had a company where you've got, generally speaking, it's fairly straightforward. If you're the director, you're the shareholder, it's pretty easy. And if you've got your wife. If you had a third party who was a director, I'd be saying, right, have a chat to John across the hall. And he will talk to you about putting in place a shareholders agreement, a buy-sell agreement. Likewise, if you had a partnership, you'd be wanting a partnership in place to cover all of those possibilities. What happens if one of the directors suddenly dies? What happens to the business? Can get messy. And that's why, like with everything, you need to have the documents in place and talk to somebody who knows the ins and outs of...
That's the key about this is who do we ask and what questions to ask? It's the whole...
Yeah. So as soon as you start talking about commercial things, so companies and trusts, you want a commercial lawyer. You might, your wills and estates lawyer may also deal with that. I don't. I choose not to. But I work closely, as I said, with a commercial lawyer. So I would be saying, have a chat to this commercial lawyer.
But it's still good you're being an expert in your field here and then put that on to someone else.
Yeah.
Which I think is a really good model. I have a team of people. I use different people for different things.
Yeah, exactly.
My accountant could do a lot of things, but...
Yeah. And sometimes you've got a firm. Obviously, if you had a big firm, then within that firm you'd have people. Yeah. So that's that. Now, then we've got all of your stuff in the US. I would say seek advice in the US. Okay? Because even... And there's no way I would even attempt to give you advice about
but there's
American
no mention
law.
of that in my will here?
Right, that's a very good question. So if you're going to have a will so generally speaking, your will will have a clause pretty early on that says, I revoke all former wills and testamentary acts. If you're going to have a will in another jurisdiction, you don't want this will to be revoking that one and vice versa. So I can put a clause in this will saying that this will relates to my estate in Australia. I would be again checking, and I'm sure you've got people in the US because you've got these documents, or these entities in place over there. Even your accountant would probably be able to point you in the right direction.
So I could just give them a copy of my will here and say, how does we fit in with?
If I died.
Yeah, I guess so. Then we need to leave that door open in this will, don't we? That not to void.
So what? No. Well, if this is your first will and only will at this point in time, we'll just make this your will, and then going forward, if you make another will in the US, you need to make sure that will doesn't revoke this one. Yeah. So we'll keep this one as just your will for the whole world.
Yeah.
For example, like I said, I don't want to be making any comments about US law, and of course, within Australia, every state's different. USA, there are many states.
50 states?
Yeah, and the law's different. Yeah. So, but what I can say is, for example, if you had property in the UK, your will here could be used over there. But then it becomes a practical consideration. So if you've got a house in the UK and a house over here, you need to deal with property in each jurisdiction. For property, you need to go through probate. There's no getting around it. So that will, and it's the original will, needs to go to the Supreme Court of Western Australia. You get a grant of probate to be able to deal with the property here in WA. Now, in the meantime, you can't do anything over in the UK because the will's tied up over here. So it may be a practical consideration that you say, right, well, I'll have a will in the UK to cover my UK property, and then a will in Australia. And you may want different executors, different people acting.
That's true.
So legally, yes, that will cover both jurisdictions. Practically speaking, it might not be ideal.
But I can't name my executor in the States in this will. I would have to have a separate will because I would have a different person handling I have somebody over there that handles all my stuff now. Yeah. So it pays maybe do another will over there.
Maybe. because what you need is a grant of probate to allow you to act. And again, this is another conversation, whether or not probate is required. So it depends how much we're talking. And also, I don't know about how it works in the US. So over here, if you had $10,000 in a bank account, you wouldn't need probate. So it wouldn't matter too much. I say it wouldn't matter too much. If you've got you need the will, but if you've got the will and the death certificate, you could show that to the bank. They can say, right, we'll close that account for you and we'll deal with that for you. We don't need probate. As soon as you've got, and different institutions have got different sort of limits, but as soon as you've got 20,000, 30,000, definitely 50,000, you need probate. In the US, who knows? Who knows? Okay. They might say, oh yeah, that's a valid will, that's a death certificate, we'll talk to you. They might say, no, we're not talking to you. You go and get that. And I don't even know if you have the equivalent. I mean, I assume you would have the equivalent of probate. Yeah, seek advice.
Yes, always.
Yeah. Okay, so distribution of your estate. You said you want to leave everything to
my wife.
And if your wife predeceases you,
then I divide between the 4 kids.
4 children equally. Okay. So then we have the clause, and again, we'll sort of do this as comprehensively as we can. If anything significant did happen, hopefully you'd be reviewing. But if, heaven forbid, one of your children passed away before you, would you want their share to go to their children if they had any?
Yes.
Yeah, and otherwise to the siblings in equal shares. Okay. So let's have a look at the age of your children. How old's the youngest?
22.
22. So they're all adults. As I've said, we've got legislation that sets out an expectation that you are going to adequately provide for your dependents. There's only a limited class of people who are eligible to make a claim, but they include spouse and children, obviously. It doesn't matter if they're dependent. So, you know, your kids could be in their 40s and 50s. Doesn't matter. They will always be eligible to make a claim. So Brendan may well be eligible. Look, if circumstances were different, if you had these 3 kids that are all the age they are and Brendan was actually 12 years old,
that'd be different.
It would be different, and I'd be saying to you, well, you need to be aware that, you know, Brendan, obviously somebody on his behalf, if he was a minor, would be able to make a claim for further provision and would possibly be successful. Given that they're all adults and you're treating everybody fairly and equally, then I suppose the question also would be, if I was speaking to your wife as well, I'd be saying, what happens if she passes away? Is she leaving everything to you?
I imagine she would leave it all to me, but if anything happened to me, then everything goes to Brendan. That's her child.
Yes, yeah. But of course, if she leaves everything to you, she's gone, everything's yours, you pass away 10 years later, then everything of hers is going to the 4 children rather than just her son. So she would need to be aware of that.
Yep, and you could let her be aware of that when she does hers. And we've already talked about this as a family, and Brendan would just divide it up anyway.
Okay.
To his kids. They all get on fine. He doesn't want it. He's very independent. He's got 22 years old, does own investment property. Yeah. He wants to make his own money.
And all families are different. But sometimes there's a very big divide, as you can imagine. So,
and even when it looks harmless on top, once the death happens, it all changes.
Yeah. I'm using your family, but other families. You've got your 3 kids. And they're your kids.
Right.
A lot of families, and my mum's family is the same. They're all the same. They don't distinguish. They don't call each other half brothers or step brothers or whatever. But a lot of families, you know, depending on the age difference and all sorts of different factors, these are your kids, and then you've got the one together. So the wife, let's change it from Rick and Karen to husband and wife, because we're not talking about you guys. We're talking about, you know, hypothetical. So the wife would say, right, if I die, I want everything to go to my husband, but if my husband dies first, I want everything to go to my child.
And she will have she'll break down some of her objects, her jewelry or things like that.
Yeah.
And she'll specify in her will that she wants that to go to her son.
Which is fine, but if we're talking more about all of the assets, you're looking at a big pot.
Yeah.
Say you got $1 million. I want $1 million to go to, if my husband's gone, I want it all to go to my son. Right? However, you say, well, if my wife's gone, I want it to go across the 4. So what you actually have to look at is, and this is a conversation I have all the time with blended families, is, well, you don't know who's going to go first. You don't know if you're going to be able to change your will. And, well, you have no control. If you leave everything to each other, your spouse can do whatever they want. So what may well happen is you say, well, if I want everything to go to my son, that's actually 50% of ours. So 50% would go here.
Half of everything we've got is Karen's, so that's 50%. And then the other kids each get 12.5%. So Brendan would get 62.5%, and everyone else get 12.5%.
If you did it like that, yeah. Or you could just say 50% to Brendan and 50% divided equally amongst.
But that happens if we both die. So yeah, I guess another reason for her to have that discussion with you.
But also again, if you were both here, for her to understand that if she dies first and she's leaving everything to you, then Brendan's perhaps not getting as much as she would want him to get. So if then we've got another scenario where you don't have a child together, you each have separate children, and I'm only going into this not for you but for the purposes of this, the question, the risk, if you like, you've got family provision applications, so that the law, the risk of somebody saying, I haven't been provided for, I'm going to make a claim. And you've also got the possibility of, let's say you pass away, and we might be talking about younger families, or actually you're not that old, your wife could remarry. What happens then? It's a whole minefield. Or those kids are not your wife's. She may not have a good relationship. Once you're gone, she might have nothing to do with him ever again. So there's no reason, and you've got no guarantee that she's going to leave anything at all to your children. Again, I'm not talking about you, but
That's not
so sometimes what people do is they say, right, well, I'll give 75% to my wife, and then I'll give 25% or 10% each to my kids. My wife gets 70%, and then it's done now when I die, so that at least they've got something. The wife's got the bulk of it and she's looked after. If she then leaves something else to them in her will, brilliant. If she doesn't, at least that's covered off. So there are other considerations that you have to look at.
It is. I think I just have to work with the scenario I got right now.
Yeah. Again,
so
for your case.
So with my but as a rule, I get that, and I can see it getting really messy too. I feel confident that my son Brendan will sort it all out at the end.
And that's
I just want to make sure that
the biggest thing
wife
about
gets everything now, just so the insurances and all that sort of stuff, because she's not going to run the business. She'll cash out and pay the debt off, and she'll need all that money to pay the debt.
And that's it. And it's all very well saying, well, let's give the kids each 10 grand or 20 grand now. I always strongly recommend against doing that, because you just don't know how much you're going to have, and by doing that you could leave your spouse short and having to potentially sell a property in order to pay out the children. So okay, so now I understand what you want to do, who's who, what you're doing. Let's get back to executor. I assume your wife would be the executor in the first instance.
Right, in the first instance.
Yeah. If she predeceased you, would it be Brendan?
No, Matthew.
Matthew, okay. Right. That's easy. So that's your son. Another question, I already know the answer in your case, but you can specify the age. So with a basic will, you just say, I give, this to that person, and they get it outright as a gift, and that's it. If you have minors, or even adults who are perhaps not so mature, and you want to say, actually, I don't want them to take control until they're 25, then we put in place a trust for them. So the executor manages that for them. The executor becomes the trustee. They have power to release funds for care, maintenance, education, but the beneficiary themselves doesn't take control until they're whatever age you specify. So I'm assuming for you, you're happy with 18.
Yep.
Again, if heaven forbid something happened to, let's say Brendan passed away, but he had little children, so you were going to be giving directly to little children, then I'd say let's put in place a trust. But here and now, hopefully, as you know, no nice way of saying it, but hopefully you'll die first.
That'll make it easier for me.
Yeah.
I'm doing all the work now, though.
Yeah. Now then there is a complex testamentary trust. Okay?
Yep.
I'll just quickly run through that. I'm conscious of the time.
Very interested in that.
Okay.
So how does that work?
All right. So the complex testamentary trust, it's a complex will. I prefer simplicity wherever possible, but sometimes it's the only option for people, and sometimes it's not the only option, but it's the best option for tax effectiveness.
Right.
So with the more complex testamentary trust will, so with the basic one, you say kids can inherit when they're 25. At 25, the trust comes to an end. That's it. With the more complex one, even you and so if you left to your wife would have the option of taking her inheritance in trust if she wanted to, and all of the children would. If they've reached that threshold age, whatever it is that you say, they can choose to take their inheritance in trust or outright. They can make that choice. So there are exceptions, and the idea behind it is trying to protect the assets. So let's say, again, hopefully it wouldn't apply, but they had mental health, drug or alcohol issues and weren't able to manage their affairs. The executor, trustee, can step in and say, no, I'm gonna hang on to this until you've sorted yourself out, and then once you've sorted yourself out, then we'll revisit it. Without that type of trust, there's no option for that. So there's no way of preventing somebody from just blowing it all, spending it all on drugs, for example. Sometimes if people are going through separations and divorce, the only thing you can do, the best thing you can do, is to set up this type of trust, and then you've got some form of protection there. How that's actually looked at and addressed is quite complex, and it's a matter for family lawyers in the family court. But from an estate planning perspective, if you're leaving to your son and you have any concerns that your son might be getting divorced and you don't want the soon-to-be ex-daughter-in-law to be having a whole chunk of your hard-earned money. Yeah.
And see how we go.
Yeah.
Fortunately, everyone gets on fine, but
Yes.
again, just seeing our recent thing, everyone gets on fine and then they don't.
Yeah. Family court proceedings, mental health, drug or alcohol issues, bankruptcy. So if any of your kids had, businesses and things and they were going through bankruptcy, then again, there's some mechanisms there to protect the assets. And finally, tax effectiveness. So there's
everything can go in there. My insurances, properties, the trust companies. Can everything be rolled up into that?
Anything that comes through your estate, through your will.
Just through my estate. So
yes.
Trust and
trusts again, they're separate.
All right.
Yeah.
Okay.
Possibly the shares in your company. Yeah, but the other entities are separate
Other entities.
Yeah.
Okay, so
that's it. Yeah.
And that's for the bulk of everything.
So yeah, in your case, if you owned 10 properties in your own name, I'd say you want to take this option.
Yeah.
Yours are already protected
Right.
in a way.
Yeah.
So in your case, yes, because you don't actually have a lot in your own name, a basic will, I'd say, would be sufficient.
Cool.
Yeah. Great. Save some money.
Yeah.
Okay.
Well, just trying to keep it as simple as possible.
Yeah.
Because it gets everything else is so complex.
Yeah.
That's
That's it. And really, your personal estate really is very simple. It's the other stuff that's more complex. And I have to stress, needs to be looked at as part of the whole picture of your estate planning.
Right. And then again, I have these other documents I'm covering over. Like this, this is where all the assets are, but another sheet of here's the bank account, here's the contact person, here's the phone numbers, here's the passwords,
You'll have that document. There's nobody that might challenge your will. There's no secret lovers or children. No. Brilliant. Okay. So, I mean, that was obviously very drawn out, but that's it. So at the end of the day, for your will, you've got Karen as your executor, Matthew as your substitute, and you're aware of what your estate consists of, you're leaving your estate to your wife. If your wife predeceased you, you're leaving everything equally to your 4 children. It's as simple as that. So, despite that long conversation, the document itself will
which
be...
I thought it would be.
Yeah.
This is how I wanted to play out. I've got a lot of questions.
Yes.
Because that's what I picked up from your talk at the library. There's just so much more to get your head around, to ask the right questions.
Yeah. Yeah. Well, I mean,
you're really
it's-
good at asking the questions.
It's up
but
to
it might
me
not
to
be
ask the
case.
question. Yeah.
But I find out, like, my accountant here is fantastic. And we sit down like this, and every document we talk about.
Yeah.
I've had 2 or 3 accountants in the States, and you give them the papers, and you come back and you sign it. And there's no conversations, no questions.
They need to find new accountants.
I keep trying, but
And then normally I would have a discussion about power of attorney and power of guardianship, the importance of those, and I'd be stressing that you put them in place.
Yep, that'll be another. And you do all those.
Yes.
So maybe I really want to be as familiar as I possibly can before I sit down with you.
Okay.
So I can ask questions again how I want that to work out.
Sure.
And so as soon as possible, but
that's fine. That's fine. So then the only other question is with regards to storage. So the reason that we offer storage is because if anything happens, it's that hard copy original will that's needed for probate.
Yes, I found that out.
Yeah. So copies don't count as it's fireproof, secure, etc. Are you happy to store with?
I think I will.
Yeah. And then when you get the other documents done, you can store those also, and your wife can store. It's not we will write to your executors and let them know, so that of course if anything happens to you and they don't know who's got the will, they'll have our details.
And so that original document, you'll have.
Yes.
Okay.
Okay, so that's all I need from you. So it's just the will. In the meantime, do you want to ask me some questions? Any other questions?
It's just an eye opener for me of knowing what your assets are.
Yes.
Because I assume life insurances and all those sort of things were part of it, but it's not. So that's very handy to know. And I'm keen to see this other document you have, the final wishes or whatever.
Yes.
And see how that works. Oh, what stage of retirement? What sort of age do people come and use your average customer for wanting wills done?
That's a really good question. I get a lot of my work through financial advisors. Which is brilliant because it's people that are sort of taking control going in and they're being told you need to get things set up. It's not age of retirement. It's when you have your first child, when you have your first property. As soon as you have something to will,
well,
you need
that's
a will.
when you should. I'm asking
that's when you should.
Your experience. What do you?
Okay, so in my experience, as I said, a lot of my work comes from financial advisors. Actually, even more, I think people are becoming more aware of the importance. So it's first home buyers. Mortgage brokers and accountants are saying to their clients, you need a will now. And it's part of their box ticking, their duty of care as well, to make sure that they're saying to people, you need these documents in place. So first home buyers, new parents. Then I see retirees, hopefully they've already had these documents done, but often it's been 20, 30 years ago when they've, the first child might have been born, but not the second or the third. And as well, I might get referrals from family lawyers, people who have gone through a divorce. When you get married or divorced, your will is null and void.
Yeah, that was something I didn't really
So retirement really shouldn't be the, right, I'm retiring, I need a will.
No, it shouldn't be, but I'm just curious if that is when...
It's actually not. I do actually see clients that are a lot younger. And then the minority are, you might have a few that are in their 80s. Unfortunately, sometimes they've left it too late because if there's any questions over capacity...
That's another question. So you never know what's going to happen, or we're going to get a head injury, or we're going to get ill, or whatever. And so having those power of attorneys and all that stuff needs to be done while we're still able to make that.
So usually by the time I'm seeing retirees, they've already done something and they might want to completely redo it or change a few things.
Because I've talked to a few people anecdotally, and they're like, they either don't have one or they've got one from the post office as a news agent or something and fill that out.
So then what it is, it's often, if I have somebody coming to me not through it's not a financial planner or an accountant that said, see Catherine, get your will done. It's because they've had an experience where somebody they know, a friend or a family member, has passed away without a will or with a homemade will, and they've seen what happens, and they go, oh, we need to get this sorted.
That's what's triggering us. And because all of us baby boomers are getting older, and so we're starting to come in contact with this scenario.
Yeah.
And so I think it's important for everyone. But it's good to know that younger people are getting on the
It is.
I think, well, that's why I first studied a will, and that was because I had kids, but it was because I was separated and had kids. And
Yes.
and so there was,
Yes.
I wanted to make sure the kids were provided for somehow, but I didn't, again, I thought, oh, it's going to be too expensive, or it's just simple, you just do this and sign it and it's fine, but that's more of a wishes than an actual will, isn't it?
Yeah, well, that's it.
And the big disclaimer again that this is in Perth, Australia. So come see Catherine. If you're anywhere else, go see somebody else. But your questions like, what to think about before you come up, that was very general information, but that would be relevant anywhere, wouldn't it?
Well, yes, I guess so. Assets definitely, yes. Guardians.
Because even if you thought about that before you went and saw your lawyer in Montana, then they can put it in context as well.
Yeah, and the way you deal with them might be different. To be honest, it probably isn't very different.
I hope you found that informative, and if you did, give me a thumbs up. Feel free to leave a comment below on any feedback you have for me, or any subjects you'd like me to look into to create a video around. The key takeaway points are: get a will done as soon as you have something to will, such as a first home purchase, as soon as your first child is born, and update it after each additional child is born. You need a new will when you marry or divorce. You need to update it if there is any change in executor or dependent status. The law covering estate planning and distribution vary from country to country, state to state. Get professional advice in your locality. Act now. You may not get the opportunity if you leave this too late. As promised, go to my website, yourjourneytransitions.com, to find some additional resources, including things to think about for your first meeting with your will advisor and your last wishes and instructions to your executor. You can follow me on Facebook, Your Journey Transitions, for updates, suggestions, and feedbacks from you, my YouTube subscribers. Future videos to accompany this video in the Advisor series will include Enduring Power of Attorney, Enduring Power of Guardianship, Binding Non-Rescinding Beneficiary Form, Advanced Care Directive, that's like a medical power of attorney, Testamentary Trust, and a document that I've created, the Rosetta Stone for Golden Widows, financial instructions for widows. Meeting preparation before meeting any professional. If you want to ensure you don't miss any of this valuable content, hit subscribe and press the notification bell, and you'll be notified every time I release a new video. Most importantly, click share. Share this with everyone in your social media. Share this with everyone that you meet over 50. You'll be giving them the gift of peace of mind, and you will be building the knowledge base of our tribe. There's a saying coming out of Africa that when an elder dies, it's like a library burning down. All that knowledge is lost. So don't take that knowledge with you. Share this site with many other people, and we can build that tribe and build that knowledge base and just provide a better retirement for all of us. And we won't be leaving a lot of hardship for those behind us. We will be in charge of our own destiny, and we'll have everything in place. Until next time, wishing you an extraordinary retirement.
This is like a cocoon.
What comes out of a cocoon?
Butterflies.
Are butterflies beautiful?
Yeah.